I call the Minister.
Sadati should be Speaker.
No. I've called...
Mr Deputy Speaker, I move that a bill be introduced for an act to amend the Rural Fires Act 1997 to provide a system for establishing, maintaining and protecting fire trails on public land and private land and for other purposes.
The question is that this bill be now introduced. All those of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. Minister.
I bring up the bill and move that this bill be now read a second time. Mr Deputy Speaker, at the last election, the New South Wales Liberal and Nationals government committed to providing New South Wales with an enhanced fire trail network. We made that commitment to assist the dedicated members of the New South Wales Rural Fire Service in their hazard reduction and firefighting duties. An enhanced, more functional and better maintained fire trail network will give the RFS and other firefighting authorities better access to areas where bushfires are, or may be occurring, as well as improved access to undertake hazard reduction works. More timely access to a fire front will mitigate the loss of life and property damage that bushfires can cause. Mr Deputy Speaker, this bill amends the New South Wales Rural Fires Act 1997 to provide the legislative basis for the establishment and maintenance of the enhanced fire trail network. It integrates fire trail management into the bushfire management planning process in New South Wales. I will now turn to the bill's specific provisions. The bill amends Section 51 to require Bushfire Management Committees, or BFMCs, to prepare a draft fire access and fire trail plan and report to their implementation to the Bushfire Coordinating Committee. The BFCC, which is already established under Section 48 of the Rural Fires Act 1997, has carriage of planning for bushfire prevention and coordinated bushfire fighting across the state. A key responsibility of the BFCC is the establishment of BFMCs, which are already provided for under Section 50 of the Rural Fires Act. BFMCs are forums for cooperative and coordinated bushfire management within their area of responsibility. Membership of BFMCs is derived from relevant agencies with local knowledge, including the New South Wales Rural Fire Service, Fire and Rescue New South Wales Police Force, the Office of Environment and Heritage, Forestry Corporation of New South Wales, Department of Primary Industry Lands, New South Wales Farmers Association, Nature Conservation Council, local Aboriginal Lands Councils and local councils. Existing key functions of the BFMCs include the preparation of a draft bushfire risk management plan and a draft plan of operations for the coordinated response to a bushfire for their area of responsibility. The bill creates new functions for BFMCs with respect to fire trails. Amendments to Section 52 require each BFMC to prepare a draft fire access and fire trail plan for its respective area. The BFMC must submit the initial plan to the BFCC within 3 years of the bill's commencement. Thereafter, a plan must be submitted within every successive 5-year period. Proposed Section 54A provides for the content of draft fire access and fire trail plans which must address appropriate means of accessing land to prevent, fight, manage or contain bushfires, and may do so by identifying or providing for the identification of suitable existing or proposed fire trails. The New South Wales RFS Commissioner may direct the BFMC to amend its fire access and fire trail plans. Fire access and fire trail plans must conform to the fire trail standards made by the New South Wales RFS Commissioner under proposed Section 62K. Proposed Section 59A requires BFMCs to submit their draft fire access and fire trail plans to the BFCC for review and approval. The BFCC may either approve the plans and revoke or vary other existing plans that relate to the area that plans cover. The BFCC may also amend the plans submitted by the BFMC. Part 3B sets out how the new fire trail and access plans will operate. Section 621 sets out the purpose of the new Part 3B, which is to provide for the establishment, maintenance, protection, certification and registration of fire trails. Both new and existing fire trails may be registered. Section 62J defines public land as managed land, unoccupied Crown land and land owned or occupied by a public authority. Private land is defined as any land that is not public land. An occupier may include a public authority that is responsible for any particular land. Section 62K sets out the requirements for fire trail standards. The section provides that the New South Wales RFS Commissioner may make fire trail standards and may vary or replace the standards from time to time. New South Wales RFS must publish the fire trail standards in the Gazette and on their website. The standards are to, as far as practical, provide for the practical network of fire trials across the state, may relate to the structure and form of fire access and fire trial plans, may relate to the reclassification, length, width, gradient, signage, construction standards and maintenance of fire trials, and will require fire access and fire trial plans to include a treatment register for fire trials that is approved by the New South Wales RFS Commissioner from time to time. Section 62L permits the New South Wales RFS Commissioner to give a written direction that a fire trial be established and maintained on public land. The direction must provide particulars of the fire trial, including its location, may apply to a new fire trial or an existing fire trial, or a combination of both. Once a direction is given, the fire trial is established as a designated fire trial. A fire trial ceases to be designated fire trial once it is registered or its designation is revoked prior to registration. Section 62ZQ provides that both designation and registration of a fire trial runs with the land. Both descriptions and registration are not affected by a change of ownership or occupation of land, regardless of whether the fire trial is on public or private land. Furthermore, a fire trial is also not affected if public land on which the trial is situated becomes private land or vice versa. Section 62M permits the New South Wales RFS Commissioner to enter into negotiations and agreements with the owners of private land to establish written agreements for the establishment of fire trials. The agreements must provide particulars of the fire trial, including its location, may apply to a new fire trial or an existing fire trial or a combination of both, must be in a form approved by the New South Wales RFS Commissioner, state that the agreement is made pursuant to the purposes of New Part 3B, and acknowledge the consent of the owner to the designation and registration of the fire trial. Once an agreement is made, the fire trial becomes a designated fire trial. The fire trial will cease to be designated fire trial once it becomes registered or the New South Wales RFS Commissioner or the owner of the land agree to withdraw from the agreement before the fire trial is registered. Where the owner of the land is not the occupier of the land, an agreement may only be entered into where the occupier has given written consent to enter into the agreement. Section 62N permits the Commissioner to certify fire trials on a public land subject to a direction, fire trials on private land subject to an agreement, existing fire trials on public land that are referred to in a fire access and fire trial plan, or existing fire trials on private land that are referred to in a fire access and fire trial plan, provided that the fire trial is the subject of an agreement to establishment of fire trial that was entered into prior to the bill's commencement. A fire trial may only be certified if it complies with the fire trial standards. A fire trial becomes registered when it is placed on the register. The New South Wales RFS Commissioner must keep a register of certified fire trials, which is to be published on the New South Wales RFS website. Land managers will also have the ability to access the register through the Guardian system. This will enable them to have visibility of the fire trials that they have responsibility for. Owners and occupiers of lands adjacent to or in the vicinity of land on which a registered fire trial is situated may make a fire trial complaint to the RFS Commissioner if the registered fire trial does not conform with the fire trial standards in any material respect. The Bill's complaint provisions are based on the existing Raw Fires Act complaints framework. Complaints must be in writing and must identify the complainant and the grounds for the complaint. The owner or occupier of the land to which the complaint relates must be given written notice of the complaint and its grounds as soon as practical after the complaint is made. Section 62S requires the New South Wales RFS Commissioner to investigate a fire trial complaint as soon as practical after it is received. However, the New South Wales RFS Commissioner does not need to investigate the complaint if the New South Wales RFS Commissioner considers it to be vexatious, misconceived, frivolous or lacking in substance. Section 62ZP provides the New South Wales RFS Commissioner or an RFS member authorised by the Commissioner to enter and inspect land other than a dwelling house to determine whether it complies with the standards. Where a fire trial is not in compliance with the standards, the New South Wales RFS Commissioner may undertake construction, maintenance and rectification work to bring it to compliance with the standards. The RFS Commissioner must also notify the complainant of any action taken in response to the complaint as soon as practical. Section 62W creates a duty on the owner or occupier of land on which a fire trial is situated to construct and maintain the fire trial in accordance with the fire trial standards. The owner or occupier is also liable for all costs incurred by it in performing that duty. However, the duty does not apply to an occupier of land who is not a public authority. Section 62X permits the New South Wales RFS Commissioner to authorise persons to carry out fire trial rectification work on unoccupied Crown land or managed land. The bill provides for the issue of fire trial rectification notices to ensure that owners and occupiers construct and maintain fire trials in compliance with the standards. Fire trial rectification work includes construction or completing the construction of a fire trial to bring it into compliance with the fire trial standards. Section 62Y permits a fire trial management officer to issue written fire trial rectification notices. These notices will require the owner or occupier of land to carry out fire trial rectification work within a time period specified in the notice. However, the notice must provide a minimum of 28 days for the work to be carried out. An owner or occupier who does not comply with the fire trial rectification notice is liable to a maximum penalty of 20 penalty units or imprisonment for 2 years, or if the owner or occupier is a corporation or public authority, a maximum penalty of 220 penalty units. Section 62Z permits a person to object to a fire trial rectification notice. Once an objection is lodged, the fire trial management officer must within 28 days either confirm the notice, vary it or withdraw it. Section 62ZA permits a person to appeal in writing against a decision on an objection to a notice. The New South Wales RFS Commissioner must consider and deal with the appeal within a reasonable time by confirming, varying or cancelling the notice. Section 62ZC allows the New South Wales RFS Commissioner to carry out fire trial rectification work if the person to whom a fire trial rectification notice is given does not complete the required work. The New South Wales RFS Commissioner may also recover costs incurred in undertaking the work from the relevant person. Section 62ZD creates a defence to prosecution under Section 62Y or an action to recover costs under Section 62ZC. An owner of land may use the defence where the owner is not the occupier and the court is satisfied that the owner had no legal right as between the owner and the occupier to enter the land to comply with the notice. Section 62ZE provides that any damage to land caused in good faith by fire trial rectification work is considered to be fire damage within the meaning of any fire insurance policy covering the damaged property, unless the damage was caused pursuant to an entry onto the land authorised by Section 62ZP. Section 62ZG provides that a fire trial is considered closed if it is wholly or partly removed or destroyed, it is obstructed so that it is not available for use as a fire trial, a sign has been placed indicating that it is not available for use as a fire trial, the trial is otherwise not available for proper use as a fire trial. Section 62ZH allows the New South Wales RFS Commissioner to carry out all work reasonably necessary to remedy unauthorised closure of a fire trial. Any costs incurred in doing so may be recovered from the owner or occupier of the land. These powers are necessary to ensure that access is maintained for firefighting and hazard reductions across the strategic network of fire trials, particularly during critical bushfire weather. Section 62ZI creates an offence of closing a designated or registered fire trial without reasonable cause or inciting or encouraging other persons to do so. The offence carries a maximum of 20 penalty units or imprisonment for 2 years, or a maximum of 220 penalty units in relation to a corporation or public authority. The RFS Commissioner under 62ZJ may terminate the registration of a fire trial or part of a fire trial either on their own initiative or on application. Section 62ZK permits an owner or public authority to apply in writing to the RFS Commissioner for determination of the registration of a fire trial. A fire trial management officer will consider the application and make a recommendation to the New South Wales RFS Commissioner on whether to grant or refuse the application. Where an application is refused, a fire trial management officer must serve a notice of refusal on the person who made the application. The person on whom the refusal notice is served may lodge an objection to the notice with the fire trial management officer within 28 days of service of the notice. The fire trial management officer must confirm or vary the notice within the 28 days and give the applicant on a notice of decision regarding the objection. If confirmed, the person on whom the notice of decision was served may appeal the notice in writing to the New South Wales RFS Commissioner within 28 days of the notice being served. The New South Wales RFS Commissioner must consider the appeal within a reasonable time and may confirm, vary or reject the recommendation. The New South Wales RFS Commissioner must terminate the registration to the extent provided for the confirmed, varied or rejected recommendation. To put it another way, an appeal might only be partially supported. Where this is the case, the registration of the relevant fire trial will be terminated to the extent that the appeal is supported. The New South Wales RFS Commissioner must also give the applicant notice of the decision. Mr Deputy Speaker, the bill provides a comprehensive framework for the establishment of an enhanced fire trail network across New South Wales. It increases fire safety for the residents of New South Wales and reduces the likelihood of bushfire-related death, injury and property damage, and I therefore commend the bill to the House.
The question is,